So the next panel is, I think we can all agree, the sort of highlight of why we're here today, to hear the case histories of the three exonerees that we've invited. So I'd like to introduce our three exonerees first: Luis Vargas, Rafael Madrigal, and Kimberly Long, along with the three attorneys. Thank you. And the three attorneys that are going to give a brief introduction to the case before you hear from the exonerees. There are a few other people I want to acknowledge in the crowd. I understand that there are some family members of the exonerees in the audience. I'd really appreciate if you would stand up and be recognized. Thank you. So with that, I'm going to ask Alexandra Simpson to come to the podium. Thank you. Oh, Raquel, sorry, I apologize. Raquel's going to speak first.
Hi guys, good afternoon. I'm Raquel Cohen. I'm a staff attorney at the California Innocence Project. I started out as a student there in the clinical internship and then hung around until they agreed to put me on salary. And my first year as an attorney on this case was 2011, and I was assigned the Luis Vargas case. I'm really excited today to be here because this is the first time Luis and I have been up on a panel together talking about his case, and I am very honored to finally be sitting here with him and not in a prison where I first met him 6 years ago. This picture, really quick, is one of my favorites. It shows two very close things and great things about Luis. Is one, his family ties and how they stood by his side throughout his wrongful conviction, and two, his graduation photo to show that he made the best of any situation he was in and actually got many degrees and did really well while he spent time wrongfully convicted. A little bit about his case specifically. Luis was convicted of 3 sexual assaults in the Los Angeles area. Each of these sexual assaults occurred in 1998 in a 4-month period. The first one is the assault of Karen P., which happened on February 3rd, 1998 at 6 o'clock in the morning. The second one was Edith G., which we're just going to come back down the map, and that was on May 30th, 1998 at 6 o'clock in the morning. And the last one is Teresa R., which happened on June 5th, 1998 at 6 o'clock in the morning. The thing about Luis's case is he was convicted because these cases were so similar. Each of the attacks of these 3 victims was early morning near a bus stop. The perpetrator asked for directions, then brandished a knife, relocated the witnesses the victims, and tried to, or successfully, sexually assault them. One thing that they had in common is the perpetrator was easily scared off. And in fact, in only one of the attacks, unfortunately for Teresa R., there was an actual sexual assault with penetration. When we got this case, I was concerned. I was concerned because we only had DNA evidence and potential DNA evidence in the Teresa R. case, but I thought, okay, all of these cases are so similar, we should be able to do something with it. I wasn't sure what we were going to do with it because it was going to be a difficult case to crack. This case had all the red flags of a wrongful ID, of a bad identification. We have the descriptions don't match Luis at the time. All of the victims say that the perpetrator did not have facial hair, and Luis at the time they proved up, although it's something that can be changed easily, he did have facial hair, so being able to grow it quickly was something that is harder to do than just shaving it off. 2 of the victims said there was 2 teardrops tattoos under the left eye. One said there was none. Luis does have you probably can't even see it from where you're sitting, but a very, very faded tattoo under his left eye, which he can explain to you if that comes up when he's talking. And you could see now in Karen P.'s identification, at first she sees a 6-pack photo lineup, and she's only 85% sure it's Luis. She narrows it down to 2 people in her live lineup and says she's only 70% sure that she's picking the right person. But at trial, she sat there and gave that damning testimony that says, that is my attacker and I'm 100% certain. Then Edith G. got up and she says, so in the first 6-pack lineup, she identifies Luis. In her live lineup, where Luis is in the live lineup, she's not 100% sure. And then at trial, she actually identifies the defense counsel first, taking a very, very long time to find Luis and identify him. Then we have Teresa R., who at her first time that she sees 2 6-pack photo lineups, and in both, she identifies Luis, but always gives some kind of description to say, well, it looks like him, but the nose is different, or it looks like him, but Luis looks younger in this picture than my attacker. And then at the live lineup, she does the same thing. She identifies him, but she's not really sure because Luis only has 1 teardrop tattoo and her perpetrator had 2. But then at trial, she sits up on the stand and is 100% certain that Luis is her attacker. At the time of trial, Luis says that he was at work. He had his manager come in and testify that he worked very early in the morning at a bagel shop. He had a coworker come in and testify to that too, but obviously the jury did not buy it. There was DNA testing done at the time of trial, but again, this was in 1998, and they took the victim's clothes, Teresa's clothes, and they did some testing and found no sperm or semen on the clothes, so that it was really not of any use for the prosecution or defense at the time of trial. But what happened was, I'm sitting there and I'm thinking to myself, okay, we're gonna get if we get Teresa's clothes, if it's still available, because at this time I'm just trying to see if they even have the evidence. And what is that going to do? So we get an unknown male profile on one of the victim's clothing. What is that gonna do? At the time, it really wasn't gonna do anything, and we were kind of frustrated at this point with the case. We were still gonna do the DNA testing, but we knew we had a huge hurdle to get over. But our best detectives sometimes are our clients who are sitting in prison and just racking their heads over what to do with these cases. And one day in the mail, Luis sends me an article about a man known as the teardrop rapist. You guys are all from LA, you may be familiar with this man, but they have not found him, he's not been caught. He is responsible for about 35 sexual assaults in Los Angeles, all with the same fact pattern as Luis's. Early morning hours, near a bus stop, asks for directions, pulls out a knife, relocates the victim, and then attempts to sexually assault them. All the victims also have varying description of the perpetrator, some saying there was a tattoo, some saying 1, some saying 0, of a teardrop under his left eye or right eye, and that's where he got the name the teardrop rapist. So when Luis sends this to us, we're all like, okay, all right. So we get a DNA profile, and we're just going to match it, and we're going to see if it matches the teardrop rapist, because he left his profile on at least 11 of the scenes in Los Angeles. Pretty exciting stuff. My favorite thing, not my favorite, but a funny story about this case is I called the police department that's responsible for trying to find the teardrop rapist, and I talked to somebody that was working on the case, and I said, hey, we just found out we have evidence, we're gonna seek DNA testing, and if we get a profile, can we match it and look at it against the teardrop rapist to see if it is the same person? And at this moment, I could see me and the police officer on the other end had 2 completely different views of what was going on. The police officer thought I was trying to put people away, and I was trying to get people off of being convicted of this crime. So we had this very awkward conversation where I was like, I want to compare it to my client. And he said, well, your client didn't commit these other crimes because he was in prison when they happened. And I'm saying, oh, I know. I want to show that he didn't do the ones that he did because it was really the teardrop rapist. And that conversation awkwardly went on for a little longer than it should have. We agreed that with a court order and with a profile that we could go ahead and do that testing. The district attorney's office in this case was amazing. They agreed to testing. They agreed to letting us compare it to the teardrop rapist, so it was a very easy procedure going forward with the testing. Some interesting facts about the teardrop rapist are, if you look at the little white dots, those are the victims in Luis's case. And then if you look at all the blue dots, those are the crimes for which they believe the teardrop rapist is responsible. There's only a few outside. I think it's a 2-mile radius that we drew that circle around just to kind of show it was happening in the same area, and again, all the same facts. So we did the testing over quite a few months because we tested a few different areas of the clothing. The perpetrator pulled down the victim's shorts and underwear, and then we went back and also we tested the area where he grabbed, and then we tested the underwear again, and what we got was a profile that excluded our client, Luis, and included the teardrop rapist. So at that point, we were so excited because we proved at least one of his crimes he was innocent. But he still had those other two. We really weren't sure what we were going to do. But with the help of the CRU and the Havlet unit, we all came to an agreement that the teardrop rapist is most likely responsible for all three of the crimes. And they conceded to the petition, and now he sits here before you. And just briefly, I'm going to show a video of his release, and then I will allow you to talk to him. Video? Thank you. Thank you.
An emotional day in an LA courtroom today. A judge threw out the case of a man convicted of 3 rapes he did not commit.
CBS 2's Randy Page explains the evidence that helped prove his innocence.
Luis Vargas waited 16 years to hear these words.
He is in fact innocent.
He is in fact innocent, Superior Court Judge William Ryan declared, of his 1999 conviction for sexually assaulting 3 victims. Attorneys with the California Innocence Project at the Western School of Law compelled the testing of DNA evidence from one of his alleged victims. The results of that test?
Our client was excluded from the DNA on the victim's clothing.
Vargas's daughter, Crystal, was 10 years old when her father was taken into custody.
Not having a father figure is difficult. You don't have that sense of protection, that sense of security. And growing up, I would cry myself to sleep.
Crystal Nunez Vargas said she got married on paper and has waited for the day she knew would come.
I'm waiting for him to come home so I can do my big church wedding and be able to have him walk me down the aisle, which is every little girl's dream. And I can't wait for that moment.
Vargas's mother, Blanca Alatorre, says her son asked her to grant one important wish the moment he becomes a free man.
He told me, Mom, when you see me, I am outside, please buy me a big hamburger and we eat it together.
But Vargas will not be reunited with his family just yet. He will first have to go before an immigration judge before he can be set free. In downtown Los Angeles, Randy Page, CBS 2 News.
Good afternoon, everybody. First of all, I want to thank you all for all this great attention that you give me. I don't feel like I deserve it. But you know what? I want to thank God, and I want to thank CRU, Conviction Review Unit. I want to thank Cal State for giving me this great opportunity. I also want to thank my great attorneys and all your champions for justice that are just making such a big difference. I remember, well, one of the interesting things my mother said to me earlier was, you know what, I'm finding this very interesting. If a lot more people would come and hear these type of speeches, events, would be a part of this, they would make a great difference in juries. And you know what, I agree. Because the day that I got sentenced to 55 to life, they had asked one of the young witnesses to go ahead and signal her attacker in the courtroom, and that was the one that took the longest. I was looking at her straight in the eyes to make sure that she recognized me. Or didn't recognize me, because I know for a fact it was not me. But instead the contrary happened, and I got sentenced to 55 to life. The day I got sentenced, I just looked at the judge and I told him, Your Honor, I'm just going to pray that God has mercy on you and your district attorney, because while you're sentencing an innocent man from these crimes to this sentence, the real criminal is out there committing greater crimes probably. Lo and behold, I found out he committed 8 more crimes during the times that I was fighting my case. But here I am, almost 18 years later, 18 plus years later, thanking God in front of you great people for the awesome opportunity you guys given me to be able to be here, enjoy a nice BLT, and see my mother, and all you. You guys are just awesome, and I want to thank you guys all. This just means a lot to me. On November the 23rd of 2016, I completed 1 year of being exonerated. I got Facebook hits from my attorneys congratulating me on my exoneration. I just thought of one thing. I don't know much about Facebook, but I got on the Facebook and I just dedicated a Facebook post to 3 very important young ladies. And I said, I do not know you personally, but I want to let you know that if you're seeing this post right now, do not feel bad that I've lost so many years because of a testimony you gave in court. It was a matter of misidentification. You probably were coached. You were the victims yourself of a broken system that needs to be fixed. And I just told them, I pray that God bless you and that God allows you to find true peace and happiness in your life to come. That's all I said. And I'm hoping that they did read it, because you know what? I hold no remorse. I mean, I hold no judgment. I don't have nothing against them. All I have is gratitude for the life that I've now been offered. And I want to thank you guys all.
Okay. Well, thank you, Luis. Is this the one I've got here? That's a different one? Sorry, while I'm messing around with this thing, okay. Okay, here we go. Oh, thank you. Thank you, Luis, for all of those comments and for making this an incredibly difficult act to follow. My name is Alex Simpson. I'm the Associate Director of the California Innocence Project. I'm going to talk to you about a case by the name of Rafael Madrigal, who's sitting here today, and he's going to talk about his experiences. And when I was thinking about what I wanted to talk about, I was really kind of thinking about it from a different perspective about what happens after the exoneration. Because we've got a number of people who are here who are waiting for some kind of compensation. I'm going to talk to you a little bit about that. And I think Rafael's a great example of maybe some of the disconnect that we think happens after somebody's been exonerated. Let's see. July 5, 2000, there was a drive-by shooting in Los Angeles. And these are a couple of the photos from the shooting. Nobody was killed, but it was a drive-by shooting, obviously a very serious crime. This is another shot of where the shooting took place. And a lot of these cases come down when you're talking about a drive-by shooting. We don't have something like DNA, usually. We don't have forensic science or evidence, usually. It really comes down to identifications. And there was an identification process that took place in this case. Rafael Madrigal, at the time of the shooting, was listed as a current gang member. That wasn't true, but he was listed as a current gang member at the time. The shooting occurred in a rival gang member's territory. So when investigators were looking into the case, one of the things that they surmised, they thought, was that this was a gang-related shooting, and I'm going to look to all of the people who are in the other gang and try to see if any of the eyewitnesses could make an identification from the people in that gang. This was Rafael Madrigal's booking photo in 2000, but this booking photo wasn't actually shown to eyewitnesses at the time of the identification process. And one of the things that we often see when we're talking about eyewitness misidentification is that you have a photo that's not necessarily the best photo to make an identification. The reason I'm showing this is because I'm about to show you the photo that was actually shown to the witnesses, and you will see, hopefully, that there's a little bit of a difference, discrepancy, a distinction between those two images, so that you might identify somebody in one photo, but maybe you wouldn't have if you had the right photo. Raphael's case also turned on identification procedures when you're talking about, does everybody understand what I mean when I say a 6-pack photo array? Yes. Right? So usually it's 6 photos that are in an array. The idea is that you try to get as many different people, or 5 different people, looking like, as much as possible, who your suspect is. One of the things that you got to make sure you do is that those other 5 people are not themselves suspects, that they're all fillers. In the event that a witness identifies one of the fillers, you know that they're wrong because you know it's a filler. If you have multiple suspects in the photo array, then maybe that person is going to misidentify the individual. This was the photo array that was shown to the witnesses. Just for your own knowledge, Raphael is number 4 in that photo array, the top right hand, second from the right. As you can see, not all of them look the same. And Raphael, this photo was taken, I think it was 5 years before? It was 10 years. It's 10 years before. And so he looks dramatically different than what he looked like at the time of the identification process. It wasn't a 6-pack. That's correct. It was a 10-pack. Yes. Our eyewitness identification expert is correcting me. This is definitely not a 6-pack. Yes. Yeah, and I'm fairly certain that the woman to the left of Raphael is not necessarily a good comparison. But this was the identification process that was used. However, even though the identification process was this, the witnesses did make an identification of Raphael, and Raphael was convicted primarily on the basis of this identification. What wasn't presented presented fully was Raphael's alibi. He was actually at work more than 40 miles away. Multiple witnesses saw him at work. He had time cards to show that he was at work. And there was a specific type of machine that was working at this plant, working at the time of the shooting. He was actually the only one who was trained in that plant to use that machine. So the individuals who could have testified as to Raphael being at work, they were never called, and they never gave that testimony. What also wasn't presented, and I apologize, hopefully you guys can read this. If not, I'm just going to walk you through it. There was a confession, an audio-taped confession from the actual perpetrator. He called his girlfriend from jail, and what he was saying to his girlfriend was, why does this guy Raphael keep asking about who did it? He needs to shut the F up about this and just take his punishment. Even though I know he didn't do it, I did it. I know he didn't do it, but he's got to stop asking. And that was audio taped and recorded and transcribed, and it was never presented to the jury. Some more of the audio tape here. None of this stuff was presented, unfortunately. And I think that had it been presented, it would have been very compelling evidence that Raphael Madrigal, I mean, why would you ask about who did it if you did it? Why would you be trying to ask around about who committed the crime if you yourself had committed the crime? And that's what basically this co-defendant was saying. Stop talking about it. Stop asking about it. I did it, but he's going to mess up my case if he keeps asking. Raphael Madrigal's conviction was reversed based on the strength of these 2 pieces of evidence. The court reversed the conviction essentially finding that Raphael was at work. And I think specifically we're talking about Robert Howards, who was his supervisor. And if you look to line 12, it says Howard's testimony, unlike the testimony of Steve Finley, who was the other guy who testified, actually chose to present at petitioner's trial was certain and unequivocal. Petitioner was at work until at least 3:00 p.m. So that was the determination from the court. That is the wonderful day that Raphael was able to be reunited with his family. That was 8 years ago? 9 years ago? That's a great story. But what happens after that? And just by a show of hands, who would go to prison for a year? Not talking about 4, 9 years like Raphael. But who would go to prison for a year for $1 million? One person? One person. I'm not offering, by the way. I'm not saying I've got $1 million. In California, if you're wrongfully convicted, you have the opportunity to ask for compensation. You only get $140 a day. It's $50,000 a year. So, none of you said that you, except for one person, said that you would go to prison for $1 million. You don't get that in California. And in fact, unfortunately, as Raphael will tell you about, you actually don't get that at all. Most of the time, when you're asking for compensation from the California Victim Compensation Board, unless you have DNA, like Luis's case, you have to establish that you're innocent. And despite a court saying that Raphael was at work, despite a court saying that another person had confessed, the compensation board voted to deny Raphael's claim and said that he hadn't established that he was innocent to a sufficient extent to justify $50,000 a year. So most of the time people kind of think about innocence and these wrongful convictions as like it's kind of like a movie, where at the end of the movie, the person gets out and then you all walk home and you say, that's great. That doesn't happen in wrongful convictions. And I'd just like Raphael to talk about his experiences in terms of the transition from being an innocent person, vindicated, exonerated, to now.
Good afternoon, ladies and gentlemen. Like you guys know, my name is Rafael Madrigal. I was convicted back in October of 2002 of premeditated attempted murder. I was sentenced to a total of 53 years to life in prison. A lot of years there. It was pretty rough. It was pretty rough, especially when you have family that's depending on you. At the time, I had 2 young boys. My oldest was 6 years old, my youngest was 3, and my wife was pregnant with our 3rd daughter. So going through this ordeal of not knowing what's put in front of you, not knowing how to overcome this, it's pretty hard. It drags your family down, it drags yourself down. The days turn into weeks, weeks into months, months into years. I was one of the fortunate ones that was only almost 10 years. Luis here was 13, 14 years. I met a few exonerees who've had 26, 27, 30 years. And like several of us already have said, we have a broken system. A lot of us already have admitted it. There's still a few out there that don't want to admit it. For the simple reason that it all comes down to money at the end of the day. Money that, me personally, you couldn't give me enough money to give me back the 10 years you took from me. Alex said $1 million a year. You couldn't give me 20 for a year of my life, for a year of my kid's life. My oldest son's getting ready to graduate from Cal State Long Beach. He's majoring in criminal justice. He could have easily took a different route in life, not having me in his life for 10 years, he could have became another statistic out there. But on the contrary, you know, he held his ground. His mom led him in the right direction, and he is where he's at now. So the other thing I want to get to is, you know, a lot of people say, okay, you're home now, everything's great. No, but it's not. You know, the minute they open that door for us, there's nothing for us to look forward to. There's no programs out there for exonerees. There's no type of help. And I'm not talking about financial help. I'm talking about mental help. A lot of us don't come out the same way we went in. You know, that's probably our biggest issues. You know, 10 years of incarceration puts you in a position where you really can't adapt back into society the minute you walk out. It's 9 years for me, and I can't tell you I'm 100%. I'm trying my best every day. I have a stable job, but it wasn't the case when I first came out. The minute I got a job when I came out, I was fired 2 weeks later when I stated that I was in prison for a crime I didn't commit. You know, so little by little you start learning what you could say and what you can't say, who you could be honest with and who you can't be honest with. You know, but you guys that are here in front of us now, I mean, you guys are tomorrow's future. You guys are the ones that are seeing our stories, hearing our stories, and maybe the day of tomorrow you're going to be a DA, you're going to be a detective, and you're going to be able to focus on what we're telling you today. What are some of the big faults that the system has? Because they're out there. No matter how they try to blindfold you guys and tell you it's not out there, it is out there. I brought a letter with me that my kids and my wife mailed to me second year of my incarceration. And I want to take the time just to read it real quick to you guys. It says, you probably feel like the weight of the world is on your shoulders right now. And if you move the wrong way, it's going to come crashing down on you. That has to be an exhausting feeling. And I wish the load didn't have to be so heavy. But I want you to know I admire the way you keep on going and keep on doing what has to be done. You might be thinking, what choice do I have? But there are many who wouldn't be able to hold up under your circumstances, who wouldn't have your inner strength or convictions for doing the right thing. I want to talk about the right thing really quick. I was offered a plea bargain of 17 years in prison. If I would have took that plea bargain, I would have been home right now. But I would have been convicted of a crime I didn't commit. I stood my ground, and I denied every plea bargain they offered me. I went as far as telling the district attorney, I will not take time served from you. No, it makes no sense for any individual, no matter what the situation is. Yeah, they might tell you you'll be home right now, but you're still going to be that convicted individual. And it goes on to say, I hope there will be pockets of time when you can find some relief and rest. I hope you will make every effort to take care of yourself because you're a good person and you're very special to many. Please count us as one of them. You know, my kids were 6 and 7 years old at the time now. Actually 6 and 4, sorry about that. You know, I could have very easily told my kids at the time, you know what, I'll be home in 5 years. I'm going to take this plea bargain and I'll see you soon. But what kind of example would I give my son now who's getting ready to graduate with a degree in criminal justice? How could I see him as a district attorney somewhere down the line, knowing that I played out to something I didn't do? So my point is, you know what, just please be cognizant of how much the justice system needs to be fixed. Take my experience, take his experience, Kimberly's experience, and help us change this. Thank you.
gonna have to compose myself after that a little bit. I'm going to talk to you about the last case that from our panel, and that's the case of Kimberly Long. And this case, we got in the year 2009, and that's not to say that Kim wasn't reaching out to us long before that. The crime in this case happened in 2003, and ever since Kim was falsely accused of this crime, she had been contacting our office. But unfortunately, due to our very limited resources, we don't get involved in a case until the trial is over, until the direct appeal is exhausted, until the California Supreme Court denies review. So, but this case really is about an all-American family. It's about Miss Long, who grew up in a middle-class neighborhood in Riverside. It's about a mother. Sorry, I'm pregnant, so now these kid pictures are like really getting to me. But and it's about a nurse. It's about your average person in the community who went to college, who got their degree, who became a nurse in the community, who is helping people with their lives. And it's about someone who fell in love with a man named Oswald Condi. They had known each other since childhood. They kind of had an on-again, off-again relationship, and were able to one had kids separately, but then came back and fell back in love together. And they had only been together about 6 months or so when this all-American life, the all-American dream, came to a screeching halt. When Kim came home one night and she found her boyfriend on the couch and his head had been bashed in. She called 911, and the paramedics came out. He was pronounced dead, and the investigation started. And the entire case came down to a timeline. Kim called 911 about 2:09 in the morning. She had a witness who had dropped her off at home who told police that he dropped her off around 1:20 or 1:30 in the morning. Now that looks bad, right? Because now you're left with a time period of almost up to an hour to have committed this crime. Kim insists that she was dropped off minutes before the 911 phone call. She had come in the house. She actually thought her boyfriend was sleeping on the couch because of the way that he was positioned. She had taken off her shoes, she'd gone into the kitchen, and it wasn't until a couple minutes later that she looked over and noticed that his head was actually bloody on one side. And went over to him, tried to wake him up, and realized that something was seriously wrong. And that's when she called 911. But her case comes down to this. And this is a quote from the United States District Court, just clarifying that her conviction hinged on one witness's preliminary hearing testimony that he dropped her off around 1:20 or 1:30 in the morning. In a series of unfortunate events, this individual had testified at the preliminary hearing but had not testified at trial because he was driving a motorcycle and ran through an intersection and was T-boned by a truck at the time and did not survive. It's a case where you have no confession, where Kim was interrogated by police officers over and over, multiple times, given a polygraph examination which she passed with flying colors. It's a case where no murder weapon was ever discovered, and the cops had scoured the area, had searched up and down all the blocks, had searched every dumpster they could find within a radius where the killer, if it was Kim, would have been able to dispose of the murder weapon. Nothing was ever found. They found no bloody clothes. It was a very, very bloody crime scene, and they found no bloody clothes of Kim's. There was no forensic evidence at all linking her to the crime, no eyewitnesses, nothing of that sort. It was simply this timeline. And the blood spatter evidence in this case became really important in the post-conviction context. But at the time of the investigation, the criminalist who investigated the crime scene actually couldn't find who the lead detective was in charge, and really had no direction at that time about what to do or what to collect at this crime scene. He went around and did document, took a ton of photos of all the different areas, and and rooms and whatnot, but collected very, very little physical evidence in this case. In fact, this is a door that's open. On the right-hand side, that's actually an open door into the garage, and there were actually bloody fingerprints going into the garage, none of which were swabbed, none of which were collected at the time. And the criminalists described the blood spatter in the house as a fine mist that was actually on every wall. It was on the ceilings, it was on the curtains, it was on everything that was around, and this will become important. Well, when Kimberly's interrogated by the police that night, they do collect her clothing from her. They tested not a drop of blood on there. And so the interesting thing is, at trial, the prosecutor's office argued, and by the way, all the spigots in the house are dry, the showers are dry, the sinks are dry, everything's dry, no water has been run at that house. Well, then they argue she must have gotten into a hot tub to rinse off all the blood on her body. And then I'm not even sure how this works, because anybody who has a hot tub and it's October and it's kind of cold out, the water, when you get out of the hot tub, is gonna be there the next morning. But I don't know, the theory that she levitated or whatnot to dry off with some unknown towel. And actually, one of the theories that the prosecutor put forward at the time was, look at all these empty rolls of toilet paper in the basket next to the toilet. She must have dried off with toilet paper, which I challenge you to get a wet hand and put a piece of toilet paper on there and see how easy it is to dry off. And that's it. This is the case. This is the case that rests on the preliminary hearing testimony of one witness. The first jury trial ends in a hung jury with 9 in favor of acquittal. The second jury trial takes place very rapidly after the first trial. It's actually during the Christmas period, where the jury actually has to break for deliberations and take the 24th and 25th off to go spend Christmas with their families. They come back the next day and they convict within 9 minutes without any deliberation. The alternate jurors in that second case had come forward after the guilty verdict and said, you know, there's not enough evidence to show that she's guilty. And the other juror had said there's nowhere near enough evidence to say that she was guilty. And in fact, the evidence was so thin that the trial court at the time commented, to make a perfectly clear record in this matter, if this was a court trial, if the court would have heard the case and the evidence in this case, I would have found the defendant not guilty. And this is really difficult case, because this is a case that is so thin to begin with, where you're sitting in the office thinking, how in the world did this person get convicted to begin with? And now we have to unravel this wrongful conviction. And it just seems, it's not an eyewitness ID case. It's not really a case where you're gonna have DNA. We have no murder weapon, and so it's one of those very, very challenging cases to unpackage, even though the conviction was so thin. We took this case up to the Ninth Circuit Court of Appeals and got this unfortunate decision where the Court of Appeals said, and it was just based on a sufficiency of the evidence claim at that time, and the Court of Appeals said, too bad, so sad, if we were the court or if we were the jurors, we would have found the defendant not guilty. We think the evidence is insufficient, but our hands are tied by all these actually great laws that were passed back in the 90s, and they couldn't do anything about it. Couldn't do anything about it. In fact, one of the judges commented, I have grave doubts about whether the state has convicted the right person in this case. Those doubts stem from the fact that it would have been virtually impossible for the defendant to have committed this crime. Even if you give her the timeline from 120 to 130 to commit this crime, and the number of things she would have to do in that meantime, of washing herself, drying her hair, disposing of murder weapons. There were a couple items missing from the crime scene, like a change bowl, a stereo, that she would have to dispose of those in a location where law enforcement to this day has still not found them. And just in that time period alone, just to accomplish all those things, it would have been virtually impossible. And we started doing some investigation and some digging into this case and really just trying to pick it apart from every single angle that we could. I'm going to show you a video, and this was a video done by CBS here in LA, right when we were getting at the end of our investigation.
Oh, she was a good girl.
Blonde-haired, gorgeous child.
She was always happy.
Then she grew up into a beautiful young girl.
A beautiful young girl who became a nurse.
She cares about people. She wants to help.
And a mother of 2 children.
we were just lucky parents. Always thought, well, my God, you know, things couldn't get any better.
Then, without warning, their lives turned upside down.
October 6, 2003, everything stopped.
It was about an hour before midnight when Oswaldo Conde, also known as Ozzy, and his live-in girlfriend Kimberly Long got into a heated argument after a long day and night of bar hopping with friends. Long, according to court records, left with a male friend, and sometime between 1:30 and 2 in the morning, the exact time is in dispute, the friend gave Long a ride home. Kimberly Long says she walked into the home she shared with Conde to find blood splattered in the living room and Conde's bloody body on the sofa. He had been beaten to death. Court records show Long called 911 at 2:09 that morning.
This crime scene was covered in blood. It was a very violent murder, and there's no way that the person who committed this murder wouldn't have been covered in blood, and Kimberly had no blood on her.
Justin Brooks is the director of the California Innocence Project at the Western School of Law in San Diego.
This is one of those classic cases where the person who finds the dead person ends up becoming a suspect.
Brooks is now representing Long. Her first trial ended in a mistrial. 9 jurors had voted not guilty, and 3 had voted guilty. When she was tried a second time, that jury convicted her. At her sentencing, the judge who tried the case, Judge Patrick Majors, said, "If the court would have heard the evidence in this case, I would have found the defendant not guilty."
Her case was paper thin when it went to trial, and now when you consider what we know since then, it's absolutely a certainty that she's innocent.
Brooks says there is new evidence pointing to Long's innocence, including DNA found on a cigarette that puts an unknown person at the scene of the crime.
And there's some significant evidence that Ozzy was dead long before Kimberly came home. But that wasn't developed sufficiently, and Kimberly ends up in this prison.
Kimberly Long agreed to speak to us on camera, but the State Department of Corrections would not allow our cameras inside the prison. So instead, we spoke to her with the help of a prison telephone. What do you want people to know about your case?
That I'm actually innocent. That if you were to sit down and actually look at my case, that there's nothing that points to me killing Ozzy. I'm actually factually innocent. And that's what I want people to know. And that this can happen to anybody.
Brooks says the Innocence Project is petitioning the California Supreme Court to get the case reopened, and he has petitioned the governor for clemency.
The governor doesn't even have to declare she's innocent. He's just got to say, we looked at the case is thin, there's some evidence of innocence, she served time in prison, and she should be granted clemency.
Do you believe you will one day walk out of there an exonerated woman?
Oh my gosh, absolutely. Absolutely. I think about it all the time. That's what I do think about. I have these whole scenarios on how it's going to happen and who's going to be there and what I'm going to say.
Kimberly Long's parents say this photo, taken just 2 months before she went to prison, captures the essence of their dreams, with Kimberly, hands at the wheel, navigating into open water.
Our daughter will come home.
And justice will be served.
You betcha. True justice.
In Corona, Randy Page, CBS 2 News.
And so I know Dustin touched a little bit on the post-conviction evidence that we discovered that wasn't developed fully at the time of trial, and mostly because she had a defense attorney that was woefully overworked and didn't do a good job in this case. It's a defense attorney who was assigned to 2 death penalty cases at the time as Kim's homicide trial, and he was handling other homicides too, not just this one. And just woefully overworked. And one of the things we looked into was the time of death issue. And we had several experts, 3 different experts, analyze the different reports to see if there was any indication about Ozzy's time of death, given that the timeline in this case was the critical component. He had a number of signs physically that happen after someone has been dead for a while. His color was ashen. He had lack of nail bed capillary refill. That's if you're pressing on your nail beds that the blood doesn't come back in if you press down on it. Lividity was present, rigidity was present. All of these things take time in the human body to develop. there was a lot of testimony in the house that the blood and the blood spatter had already dried, which also takes a significant amount of time. And we had Drs. Benel Hua and actually Sarah Wecht, too, who we consulted, who determined that that Mr. Conti was dead long before 1:20 a.m., which was the first possible time period, according to the prosecution, she could have gotten home. We also did DNA testing on a cigarette butt that placed an unknown third party at the crime scene. And the way that this was significant is that Kim didn't smoke, Ozzy didn't smoke, and yet there's a cigarette butt right there on the coffee table in an ashtray that had never been tested by the defense. We did DNA testing on, I mentioned that there was a missing stereo, but actually the speakers were left, just the stereo console had been taken. And we did DNA testing on the speaker wires that would have had to been ripped out of the actual center console of the speaker, and there was DNA present on that, and Miss Long's was not present. We also found evidence that pointed to a third party as possibly being responsible for this crime. This was just a couple weeks before he died. The victim got a restraining order against his ex-girlfriend. And these are statements from the victim in the restraining order, that she called me and she said, my girlfriend's gonna get it and for me to watch my back, and she's not gonna let me see my son. And she said that she hates my girlfriend and she's going to ruin our lives. And the jury heard none of this. We also had evidence that she did not change her clothes. And this was important because the defense never proved up that the clothing collected by the cops that night from Kim were the same clothes that she was wearing when she was dropped off by her alibi witness. And that was important because the prosecution just argued, oh, well, she just changed in some different clothes before the cops interviewed her. You know, washed off in the hot tub, put on some different clothes. But that wasn't the case, because the original interviews with her alibi witness described exactly what she was wearing. A black t-shirt that had some designs on it. I'm thinking biker rock and roll stuff or something. What I remember were like little chains, it looked like a chain that was part of the shirt. And you can see those chains right there on both sides of the shirt. She was wearing blue jeans, kind of lowrider blue jeans, and I think she had a black belt on. And what looked to me like a suede jacket that had a fleece lining, like a winter coat, like something you'd wear to go play in the snow or something. So these are the clothing that was collected from Kim that night. It's the exact clothing that she was wearing when her alibi witness dropped her off. And based on all of this evidence, and again, this is one of those cases that's very hard to unpackage because it's a case that was so thin to begin with, but based on all of this evidence, the original trial judge reversed the conviction, and she was exonerated after spending 7 years in prison at the time. So, Kimberly?
Hello. I've never stood at a podium before. I'm used to sitting down. I was actually arguing with my attorney. I was like, I'm not standing up. I'm not gonna stand up. You know, it's always hard to listen to your attorneys tell the worst day of your life, especially when it's about your loved one. You know, when they talk about lividity and rigor mortis, that's like the worst thing, you know, a person can hear. I was, October 6, 2003, I was 27 years old. My children were 5 and 10. I got out 9 months ago. I am 41 years old, and my kids are 19 and 24. It's still going on. It's been 14 years since my boyfriend was murdered. And the DA is appealing the judge's decision. And the DA still wants to retry me. But I am unbreakable. You cannot break me. You cannot make me admit to something I didn't do. And they could not break the bond between me and my children. My children are doing great today. My daughter's graduated from Cal State San Bernardino. She wants to be a police officer. Having a hard time, she's too honest. She has too much integrity, I guess, I don't know. My son goes to a Cal State, somewhere in LA. Told him I wouldn't say that. And he's gonna be a nurse. You know, the hardest part about having all that time away and getting out is you're trying to find your purpose. I'm the first woman to be exonerated from the California Innocence Project. And I was a mother of 2 small children. So there were places to go, there was homework to do, there was baths to be given. And now I don't have that purpose anymore. Everybody's out of the house. I don't cook dinner. And I'm trying to find my purpose in life as a woman and as a mother of 2 adult children. And sometimes that's really hard. And I think, Raphael, you said it pretty good about just everything with the judicial system and you all being the future, and coming here today and listening, taking time out of your Friday to hear us. That really does mean everything to us. I don't want to stand up here too long, but thank you so much for coming. It's a very humbling experience. Thank you.
He's on. So, audience, now is your opportunity to ask questions of any of our panelists. Kate and I both have microphones, so we're going to come around. If you just raise your hands, we'll approach you when you have questions. Kate's going to take the first question. Bethany? I forgot.
Yeah, so that's a great question, and it is something that I think a lot of people have a misconception about, that that the state, the government has only one opportunity, one chance. The way that it works is that there's a little thing called double jeopardy, and it basically means that the prosecutor can't retry you for a case that you've been acquitted from. So if the jury comes back and says that I find that this person is not guilty, then the prosecution can't retry you. But if it's a hung jury, if some of them say, I don't believe the state has met its burden, and others say, I think they have, then what happens is that the prosecutor has the opportunity at the end of it to re-prosecute. And the unfortunate thing is with Raphael's case and potentially with Kim's case, that is something that they've had to go through. Raphael was, I think, 2 years while the prosecutor, even after the judge found that he was at work, even after he found that another person confessed, the prosecutor took a couple of years to make absolutely certain that they didn't want to re-prosecute in that case. And in Kim's case, even though we had all of the evidence that Alyssa described, there is a possibility. They've appealed that decision. And if they lose the appeal, then they've at least said that they intend to re-prosecute. So it's a very, very difficult process. It's really unfortunate that people have to go through that. It's like having to go through this nightmare over and over and over again. And that's not, I don't think that's how we really want to have the criminal justice system work.
There is no limit, though. Alex has given an example of where it's happened a couple of times, but there's actually no limit. So we've had cases where people have been tried 4 or 5 times. That always gives you pause, because you know that in every one of those cases, at least 1 or 2 jurors thought there wasn't sufficient evidence to convict them. Provides no limit on the number of times you can be tried.
I want to thank everybody who's on the panel and who has spoken today. First and foremost, it's been very enlightening. I do want to touch upon a subject that various of the panelists have brought up about the National Academy of Sciences, of how they are an independent group of scientists, and how recently the Attorney General of the United States has ended their partnership with this group of independent scientists from all different fields, and how he's also suspended reviews of FBI cases. How does that affect the work that the Innocence Project has going on and will take on in the future?
First of all, we are so disappointed with what is going on in Washington with that. In fact, I mean, I know a couple of the different panel members and stuff who are part of those forensic science commissions and stuff. I was actually on the forensic odontology one, I think only because that they needed a defense attorney to be on the panel. So I was like the one nay vote for most of the stuff that we were discussing. But it means that we need to be ever more diligent in what we're doing and the type of evidence that we're presenting to the courts. And that the courts, that we educate the courts as the defense bar or as prosecutors, that educate the courts on what really the science is. It means, I think for us, that the ball is now in our court and that we are the ones who are going to have to make the change judge by judge to make sure that only valid, legitimate science is used in criminal cases.
But as the old man up here, I remember when Janet Reno, first got the first group together to really look at the forensic sciences and look at wrongful convictions, and it was a huge, huge benchmark in our work and in what we do. And now we're going in the opposite direction of that. So I'd say absolutely devastating. Alyssa's right. We're going to have to go back to the old-fashioned way of winning case by case, judge by judge. But the fact that we're breaking up science away from the criminal justice system is not a good thing.
Hi, my name is Vanessa Nunez, and first I would like to thank you guys for being here as well, because I know you guys are thanking us for spending our weekend here, but you guys have already spent so much of your time, and so thank you for being here. So I guess my question is in regards to what Mr. Rafael Madrigal said about the change in the criminal justice system. And it's kind of, I want to get your opinion on discretion, because there's discretion throughout the whole criminal justice system, which impacts all cases. For example, we were talking about, or rather you guys were talking about Brian Banks. And to me, there's similarities between Brian Banks and Brock Turner with their athletic abilities and the school's interest in them, yet both cases were treated so differently. So my question is, since you guys deal with different but similar cases, what are your opinions on discretion in all levels of the criminal justice system, and whether you guys personally think there can be a change? Because I've been trying to think of changes, but I'm just a student and you guys have more experience.
You seem to be dancing around. Is your question whether race impacts the criminal justice system? Race and class and money. Okay, so let's talk about it. It absolutely does. And I'm not saying that people don't go to work every day trying to do the best they can, and that people don't try to have race impact what happens. But the reality is that it just does. And the first lesson I had for that was when I started as a criminal defense attorney in Washington, D.C. And D.C. is the most liberal place in America. And the Washington Post is always hailed as the most liberal major paper in America. Yet every single day, a black kid was killed in D.C., and it was always in the metro section. And whenever a white person was killed, it was always on the front page. And it starts as simple as that. That's the sort of thing that it becomes less news when a black kid dies. It becomes less important. There's less focus of the system. There's less pressure. And there's just no way to deny that this kind of racism and classism exists in our system. There's no way to deny that the more money you have, the more services you can get, the more investigation you can get. I mean, just like I said this morning, it's so great that we've all kind of accepted in the police community, the prosecutorial community, the defense community, that wrongful convictions happen so we can start addressing them, and we'll never get rid of that, but we can address it. It's the same thing with race and class within our system. We can do things to do better. There's no doubt about that, in terms of resource allocation, in terms of how we select juries, in terms of how we focus on cases. But the first thing we have to do is be honest about it, because it's just ridiculous. It's so obvious that it's absurd. So yeah, Brian was personally pretty upset about that case because he looked at his own case and thought, you know, I was sent to prison for 6 years because I was accused of rape. And now here's another case of a guy who's also this athlete who's white and has money and ends up getting a different treatment within the justice system. Is that necessarily fair to look at a study of one? No. But there's no denying that it's reality.
I absolutely agree that is a difficulty. There is a problem that we have with resource allocation with regards to how many, no matter what jurisdiction you're in, defense attorneys generally, if you're working for the public defender's office, you have too many cases. If you are working as a private defense attorney, you have too many cases. And any time that happens, that means that you are likely to have a case fall through the cracks. As to what happens in those situations, it's kind of this kind of fiction that we have that, you know, yes, we can see that there was problems. There are, if it's very egregious, then there might be something, there might be discipline, there might be disbarment, but it's also a little bit like, wait a minute, you can't give me 200 cases, 200 felony cases, and expect that I'm going to be the best possible attorney. That's the kind of the push and pull that we see in, especially in large jurisdictions like Los Angeles. You know, Los Angeles County, the public defender's office has a ton of cases, and they're not going to be able to process them. It also kind of goes back to the other question about what's the problem with discretion. The only way that the criminal justice system works as it currently is constructed is by being able to offer plea deals and get plea deals in 95+% of cases. Which means that if you're talking about a person who is being charged for a drive-by shooting, then most likely, most of those cases are not going to get sufficient investigation because there will be an offer on the table, and the hope is that the defendant accepts that offer, and then you move on to a different case, because that's the best you can do. So it is difficult. There are egregious cases on both sides where attorneys have really done a really terrible thing in terms of the representation of their defendant or representation of the state. But most of the time, we're just trying to tread water. And I've got to get to the next case. And if I miss something, it is often as a result of the fact that I have too many cases on my plate.
Yeah, and then speaking of egregious examples, we had one case where the defense attorney conducted zero investigation. The entire trial lasted, I think, one afternoon, and it was 2 cops saying that they pulled into this bar parking lot and saw our guy toss a knife underneath a nearby car. That was it. That was the whole trial. The guy gets struck out 25 to life on that. And when we went back, there were a ton of people in the parking lot who were witnesses to this entire event, who knew our guy didn't have the knife. Who, in fact, we had witnesses who were a police officer from South Carolina, like really great witnesses, not even terrible witnesses. And our student calls the defense attorney, who was in private practice at that time, to say, well, hey, did you ever talk to any of these people? In fact, he had their names in his defense file, but did you ever talk to any of these people? And excuse my language, but he said, his response was, oh no, did I fuck up another one? And by the way, he had at that time been disbarred for other failures in other cases and stuff too. But we do have cases of egregious examples of defense attorneys just messing up. And then you have the case of, like in Kim Long's case, where you have a defense attorney who's just woefully overworked. And so kind of those two extremes.
You know, also going back to your race and class question a little earlier, you know, one of the cases of the last 10 years that got the most discipline, the most attention in terms of people were going to pay for it was the Duke lacrosse case. Now, again, I don't want to say it's because it was rich white kids at Duke that were being prosecuted, but those kids didn't even go to prison like our clients up here did. And they ended up getting compensated, the district attorney was fired and disbarred on this case. A whole bunch of people were disciplined. Again, I don't know what the difference was, but I saw a bunch of kids from Manhattan who went to Duke who were lacrosse players that ended up getting a case that had a lot more attention than some much more egregious cases that we see every day.
Yes, I just wanted to thank you, first of all, for this opportunity. My question is to the attorneys. This outcome that we're seeing of too many people, innocent people, being put through this type of tragedy, do you think it has a lot to do to the criminal system being screwed up from the very beginning, in the sense of pretrial processes or pretrial procedures that are really being pushed through kind of in a conveyor belt mentality because of the the workload? For example, preliminary hearings, for example, to me, where you're trying to show probable cause, to me it seems that would be a good place where most of these types of unbelievable cases should get thrown out. But in a way, I think preliminary hearings end up being like kangaroo mini courts, where things just get stamped through and moved on. And it doesn't make sense to me when I hear about some of these facts that were key facts that should have come out aren't. What happened at preliminary hearings? I mean, at least from my own experience, it's not really serving what it should. Shouldn't we have something more like clear and convincing evidence or something, a higher burden to prove at preliminary hearings?
Go on. You've been through a prelim.
That's funny. What I know about prelims is that, your defense attorney doesn't get a chance to put on everything. We did not get a chance to cross-examine Jeff Dills, the guy that died in my case, their star witness. We weren't able to cross-examine him the way we would want to, because that's just not how it's done in a prelim. So then our right is shot, because I think we brought it up in the appeals court somewhere along the line. I've been through all the courts, so I'm not sure where it happened, but we weren't able to bring it up anymore. Here's a real attorney.
Sorry. Just play one. I don't think it's different than anything else in life. I think we're crazy to think it would be. The more we're doing stuff, the more volume, the more mistakes. And that's whatever you're doing, whether you're a plumber or you're a drywaller or you're a chef or you're whatever. I mean, I worked at the only McDonald's in Puerto Rico in 1979, okay? And when we opened our doors, it was insane. It was the busiest McDonald's in the United States. We had 14 registers. We only closed for 1 hour at night to quickly clean and then reopen our doors. Let me guarantee you there were a lot of mistakes that were made. One of the things was we used to use the same bucket that we mopped the floors with to fill up the shake machine. Listen, I'm a vegetarian. I haven't been back since. But It's like everything in life. As soon as you're overworked, overwhelmed, you start cutting corners. We're human beings. We're not robots. I mean, I tell my students that when you get out of law school, file lots of really good motions. Immediately, don't set yourself up that you're an asshole, because you don't want DAs to hate you. And if you're a DA, you don't want defense attorneys to hate you, but you want to make the other side work hard, because the harder the other side is working, the more difficult it is they're going to see you going up against you, the more likely you're going to get better deals, the more likely things are going to result better for your client or for the state. It's just like everything else in life. And the United States has the biggest prison system in the world. And California, we have the biggest prison system in the country with the biggest prison system in the world. So there is a lot going on here. And I do think processes are better here than what I've sat and watched in the Deep South in terms of, I was down in Georgia a couple of years ago. I had an intern there, and it was just a row of guys waiting to do their plea bargains. And they were literally meeting with their attorneys on the same line as they approached the judge to plea their case out. There was no meetings with them before that, and I pulled my student out of the internship because I didn't want her to learn habits like that. But the more the system's overwhelmed, the more mistakes are going to happen. That's just the bottom line.
I just have a question about false confessions and why they're not, the interview is not taped. As far as I know, I think there are like 2 states that have a law on that and a few cities that require that. But I mean, when you look at like the Central Park 5 and Making a Murder and just amazing, why isn't from the beginning to the end of a police interview process, why, I mean, is the Innocence Project trying to make headway on that to try to make it a law?
Iris, do you want to answer that? You're sitting there. That was your topic today.
It's pretty simple. Things are changing. Pretty much most people involved. Can you hear me? Is it okay? You know, law enforcement, DAs, public defenders, scientists, they all agree that that's the best way to try to prevent, you know, people that falsely confess from actually going to prison. So the videotaping of interrogations is something that we're seeing a lot more. So that's changing for sure. What is it going to be a law? Yes, it's becoming more established in different places. So now, because it's so easy to videotape the entire confession, the entire interrogation, we're seeing a lot more of that. But you know, for me, that's great, and that's, you know, that's a great change that we're seeing. What's going to be important is to have experts to be able to inform both law enforcement and the jury about what's going on, because it's not clear that jurors, even if they see an interrogation, that they can pick up all the tactics and the process and why is it that that person confessed. So we need not just the videotaping of interrogations, but also experts, people that can interpret or advise on what's going on in the interrogation, so that we can prevent people who falsely confess to be wrongfully convicted.
And just to add to that, you know, direct response to your question with regards to California, there was a law that there are 2 laws that passed in the last 2 years. The first law that passed 2 years ago was that for all juvenile cases, if they were accused of murder, that interrogation had to be recorded in some way, either audio or video. We expanded that last year to include all murder cases. So not every case, but all murder cases. The goal is to have all of those recorded. And it is not just to make sure that we have wrongful convictions, that we have evidence of a false confession, for example. There are a number of jurisdictions that have implemented mandatory videotape recordings of all interrogations. And what they have found, law enforcement has found and has testified in a number of different proceedings, that they actually prefer it. Because at the end of the day, if somebody comes forward and say, oh, you know, that police officer, they were really trying to, you know, they used all these coercive tactics, law enforcement can just play the tape. And they can say, look, that wasn't what happened. And so it really is a very good thing, not just for the securing of evidence to establish that the person has falsely confessed, but also to prevent against those frivolous claims that people might have that show that they were in fact correctly confessing. So I'm a wholehearted supporter of recording all interrogations for that reason, and also recording eyewitness identification procedures. That would be great. That's not on the books yet, but we would love to have it.
Melvin Campbell, Los Angeles County Sheriff's Department. This question for Mr. Brooks. Do you see any improvement in bad identification testimony? And if not, would you support the Canada approach with snitches?
I would definitely support the Canada approach with snitches. I just think, jurors don't fully understand what's going on with a snitch. I think, and sometimes it is just legitimately someone comes forward with good information and it's totally credible, and other times it's just ridiculous. I've had too many cases where people have completely fabricated testimony, and it's so difficult to get a jury to really understand what's going on there. Have I seen improvements in identifications? I think the public is becoming more aware of it. I hope. There's been so many people who've walked out of prison after bad IDs. I think events like this help. We're educating jurors. We have a jury system in this country. I think we need to do more training with lawyers on how to educate jurors about it. Like, for instance, I've read transcripts where they just seem to have no concept about how to talk about cross-racial identification without it just sounding weird. And without you making the jurors feel like, you calling us all racist? Of course we can figure this out. And you're calling this woman a racist because she can't ID black people? And that's where we need to do some more education. So I don't know if we're there yet where we're improving it. We're certainly improving on our side, and I think the DA's office is improving on their side in recognizing the problem and remedying it later on. And there's more and more ID experts like Iris, I think, all the time. There seems to be this is like the second generation of experts coming up on IDs, and that's great. So I think we're seeing some improvement, but our human brains are still the same, so that's not improving, and we're never really going to be good at it, so we can't fix the problem. And that recommendation is great until Jeff Sessions sends a memo. Disregard prior information about scientific invalidity of identifications.
I'd like to ask Doreen Long a question. I'd like to ask how Kimberly's exoneration and the initial wrongful conviction impacted you and your family, if you could speak from the family's perspective.
Well, as our daughter would say, it's a long road. I don't think any family wants to find themselves there. Pray to God you don't. My daughter, Kimberly, always told me, coming home. And I used to post that all the time because I believed it. The exoneration for what the CIP done, the California Innocence Project, Alyssa, Justin, Alex, Michael, all of you are awesome people. To do what you're doing, I think you know I think you understand. I'm a mom. I think you understand where I'm coming from. It's very hard to run a speaker. We're so excited. We're elated at my daughter's home. There is so much more
to do because the nightmare is not over. We fought together. She came home. All of you've got to do the same thing. Every citizen, you all got to do the same thing. When you see something that relates to wrongful convictions, get on that site, read it, post it, do something. Help us pass some bills. At least maybe we will never stop wrongful convictions. As Justin said, I am sure we probably never will because we work with humans and they fail. Their integrity is low when they get in a courtroom. It's very sad. I still have hope for the justice system, but with all of us, if we don't work together, we're not a driving force. So, thank you to my daughter for always saying, Ashley gave me the strength. I'm coming home. Thank you to the California Innocence Project. You guys are awesome. Thank you.
All right, before you go, we actually have one last little video that we wanted to show to you.
So, you know, one thing we don't think about often is the impact on families of being wrongfully incarcerated. That's why I think it's so perfect that Darlene just spoke. Because it does. There's this huge circle of pain around the person who's in prison. And I talked earlier about the Uriah Courtney case, who had been misidentified of that sexual assault, that 16-year-old girl. And California has a law that when you're incarcerated for a crime against a child, you can't visit with any children, including your own. So the entire time Uriah was incarcerated, he couldn't see his son. And when he went to prison, his son was 2 years old. And when he got out of prison, his son was 10. And so Alyssa went to the airport and we flew his son in. And here's Uriah seeing his son for the first time after being in prison for 8 years.
Extremely excited. I could not wait. Since 2006, today I get to hug my boy for the first time. All the tears.
That's why we love doing the work we do. Thank you very much.
So that concludes our program. If you would please stand and acknowledge again our presenters.